is. It's been a 3-day week for us because of the snowstorm, but it certainly feels like a full 5-day week. But we're excited to get started this morning, so we'll go ahead and begin with roll call.
Senator Cooper?
Here.
Senator French?
Here.
Senator Kolb?
Present.
Senator Cost?
Here.
Chairman Nethercott?
Here. All right, well, committee members, I have a couple of bills to present this morning over in House Judiciary across the hall. So I will be turning the meeting over to Vice Chair Cost. To start the meeting off, we have Representative Stith with us this morning to present 2 of his bills. Dissemination of an unlawful image. And so welcome, Representative Stith. Committee members, Representative Stith is a former member of House Judiciary for the last few years and a very helpful and valid member there. And he has now decided to go to the Appropriations Committee on the House side. So the poor soul. But it's great to see you back over here on the Judiciary Committee. Representative Stith, the floor is yours, and I'll turn it over also to Vice Chair Cost.
Madam Chairman, thank you very much. Members of the committee. And so I guess my question is, which bill would you prefer to address first? We have House Bill 46 and House Bill 85.
Representative Stith, according to the order that the Madam Chair had arranged, we'll go with 85 first, and then we'll move on to your second one, which is 46. Okay. So take us away on House Bill 85.
Great, thank you. Mr. Vice Chairman, members of the committee. So House Bill 85, the problem that it addresses is that we have a gap in the law right now. What is commonly known as revenge porn is not a crime in Wyoming. So there's a handful of states where it's not a crime. The way that I became aware of this in my community was that I had a client who had engaged in activity that might be considered revenge porn, what you would commonly think of that. But because there was no particular statute that it applied to that conduct, the prosecutor really was in a sort of a difficult situation. He either had to charge nothing or he had to try to shoehorn the conduct into some other category. And so the prosecutor in that case decided to allege that it was aggravated blackmail. And the problem with that is that carried a potential 25-year prison sentence and a minimum 5-year prison sentence. So you have the prosecutor trying to shoehorn, your typical case is where you've got a jilted, boyfriend, say, who then has an intimate image that he got initially consensually from his ex, and later he's unhappy, and so then he's using it, either posting it on social media or otherwise using it to humiliate, embarrass the ex, right? That's kind of your standard situation. So in that particular case that I was involved in, the charges eventually were dropped, and my client, didn't really do any jail time at all, which of course, from a lawyer's point of view, that sounds like a victory, but it didn't really feel like justice, frankly, to me. So I thought, well, hey, we've got this gap in the law. Let's try to fix it. So walking through the bill so that's the problem they're trying to solve. Walking through the bill on the first page, we have sort of definitions that are relatively common sense. I would note on under A, Romanet 2, the definition of disseminate says means to sell, distribute, deliver, provide, exhibit, post on social media, or otherwise make available to a third party, but shall not include displaying an intimate image in private to the person depicted in the image. So that would mean that it's not considered dissemination if you're only showing it to the person that's depicted, then you're not sort of publishing it to the world. And it's by analogy to the law of slander or defamation, that if someone comes up to you and makes a false statement to you about you, that would be slander. If they only tell it to you, in the law, it's not actually slander because it's not damaging your reputation because no one else is hearing it. We're sort of by analogy to that. That's why the definition of disseminate is limited in that way. The definition of image, intimate parts, sexual acts, social media, those are all relatively, I think, standard in the sense that I don't think they capture more than what's intended. The next curious part about this bill is you'll notice on subsection B, it says a person 18 years of age or older is guilty of the offense of disseminating an intimate image if the person. So you may wonder, why are we making it 18 or older? Why that? Why does this not apply to juveniles? And the reason, so the choice here not to apply it to juveniles is because a few years ago, the legislature adopted what was called like a sexting statute that dealt with this same type of conduct, but among juveniles. And the idea was that juveniles are in a slightly different situation. And so in this bill, I didn't want to disturb what the legislature had done 3 years ago with respect to dealing with that problem in connection with juveniles. So in the original draft of the bill, we only had two elements, which were disseminate an intimate image of another person, and when you knew or should have known that the depicted person had a reasonable expectation that the image would remain private, and the depicted person did not expressly give consent for the image's dissemination. So the original bill just had those two elements, and then the House Judiciary Committee, I think quite helpfully, added this third part, which is the Romanet 3, which gives sort of a mens rea, the guilty mind aspect, that what's the state of mind, what's the intent that you have to have when you're disseminating this image. And they broke that into two pieces. The first piece is sort of more common sense, which is to humiliate, harm, harass, threaten, or coerce another. And then under Romanet 3, capital B, or if you intend for sexual gratification or arousal of others or of the person disseminating the intimate image. Okay. So this mens rea element, there was quite a bit of discussion on the House Judiciary side about that. I think it's actually important, and on the House floor too. I think in other states, these statutes that make revenge porn a crime, there have been challenges to the statute based upon First Amendment free speech grounds. The defendant has said, hey, I have a free speech right to post this work of art, or have that as a justification. And so therefore it can't be a crime because I'm just exercising my free speech rights. And so this First Amendment analysis is sort of interesting because there is a First Amendment concern. To cut to the chase, basically, courts, Minnesota most recently, just a couple of months ago, upheld its revenge porn statute as constitutional and not violating the First Amendment, in part because they had an intent element. That is, if you're intending to harm someone or if you're intending to harass them, then that's not protected speech. So the intent element helps preserve the constitutionality of the bill. And then finally, and then reasonable people can disagree about this. Finally, the subsection C, dissemination of an intimate image is a misdemeanor, punishable by not more than 6 months imprisonment, a fine of not more than $1,000, or both. So you may wonder, well, why is it a misdemeanor, not something else, not a felony, for example? That's an interesting policy choice. You may choose to amend this. You may choose to say, if you do it a second time, second offense, maybe it should be a felony. Maybe you want it to be a felony the first time. That's your choice. I think reasonable people can disagree about that. The reason I drafted it initially as a misdemeanor is that I don't like to create felonies if I don't have to. Felonies tend to have more of a burden on the judicial system. That is, prosecutors spend more time, public defender spends more time, the jails, the prisons spend more time dealing with felonies than with misdemeanors. But it's sort of up to you to make the choice that you deem appropriate on this. And I don't really have a big, to me, my concern is just that we close this loophole. That's my biggest concern about this. So if you have any questions, I'd be happy to. I'll stop talking. And
Mr. Chairman, I don't believe I gave you the green and gross copy that has those changes that he was talking about. I'm going to run down and get the right copy.
Okay, thank you. I happen to have copied the engrossed one off of the internet, so I have it. One question I'm going to ask, and then I'm going to, when you said mens rea and intent, do you see that as something My concern would be, it's kind of difficult to prove intent, isn't it? So does that put this in a kind of a jeopardy type situation?
Vice Chairman Cost. Yes, in fact, that's why my initial draft of this did not have the intent element, in part because I ran it past our local county attorney, who said that very thing. He said, well, it'll just be harder for us to prove. And it's true that it would be more difficult for the prosecutor to prove. On the other hand, it is generally true that for crimes generally, for common law crimes generally, whether it's theft or burglary, typically there are two basic elements of a crime. You've got the voluntary act, the actus reus, and then you've got the guilty mind, the mens rea. And so typically for common law crimes, you want to have both. We don't like having strict liability crimes. Typically, we do have strict liability crimes. You know, driving under the influence is a strict liability crime. Doesn't really matter what you're intending. If you're driving drunk, you're guilty. But upon reflection, I think it's better to have this mens rea element because it guards the statute against being unconstitutional. So there's that advantage to it. And then, although I suppose theoretically it's possible that you would have a person who would yeah, I guess that's all I have to say about that. If you choose to strip out that part, that's your choice.
Thank you for that. It's just something that kind of, this and the voyeurism bills and that, it just kind of is intent going to cripple the bill. And so that was my only concern. Thank you. Okay. Senator Cole, you want to have a comment?
Thank you, Vice Chair. Representative Stiff, I had a few questions kind of came up. Page 2, line 11, the Romanet 3, III. And at the bottom of that, I guess it would be line 13 actually, purports to represent an identifiable person. Is that clear in the courts, I guess, what that really means, like the actual context of that photoshopping or live video, splicing the head onto another person, I assume is what this means. What is your feelings on that is one of the questions. And then over here on page 4, line 12, where it talks about the fine. I am concerned that if it was used for commercial purposes and you actually sold this image, you made money on it, is $1,000 enough? Or is there some sort of upper limit to this that can't be exceeded? I just wondered if that was a little low, if the person was actually involved with making money on this production of said image or whatever video, and your thoughts on that also. Thank you.
Madam Chairman, Senator Cole, certainly the computerized image they referred to, the purpose there is that it wouldn't, since that is included in the definition of image, it would not be a defense if a person were to, create the computer generated image of, someone, whether it was their intimate parts or someone else's. If it purports to be them, it would still be included. I suppose theoretically you could make the argument that I think it's better to include that. If we don't include that, then essentially that would become a defense, that it wouldn't be revenge porn so long as I created a computer generated image. I might use your actual likeness, but then put someone else's body with that. I think from the victim's point of view, I think they would feel equally sort of victimized, I guess, if it's a computer generated image. But it does raise an interesting issue of, it does play into the First Amendment analysis, actually, of what is art, what's free speech.
Well, follow up on that same line of thought. I guess I wonder just how low the bar was, if there were some explicit boundaries that if they were crossed, then clearly you would fall under the statute. And say if it was a lesser issue, would there be, I wondered how low the bar would go, I guess, like if you were going to pull somebody in saying you made me look like Mickey Mouse, and I was offended by that, and that's revenge.
Madam Chairman, Senator Kolb. So the definition of image includes computer generated images. However, it must also be an intimate image. And so that's where Romanet 4 comes in. So if you're just putting, say my head on Mickey Mouse, I think that's not going to qualify because it would be an image, but it's not going to be an intimate image under Romanet 4.
And then the intimate image, though, could be all computer generated. I mean, the part that's intimate could be computer generated with someone else's head on it, right?
Yes.
Okay.
Yes. And with respect to your other point, this statute is drafted in kind of plain vanilla fashion. It is it's in Title VI. It would be a criminal statute. The statute does not itself create any civil cause of action. You alluded to a potential civil cause of action, but the statute itself does not create that. In other states, there have been copyright claims that have been filed by the victim. If the victim had taken the picture and asserted an ownership interest in the picture, then that can be a separate basis for a civil cause of action. Would it be a good idea to create a civil cause of action? Maybe. From my point of view, I think that'd be the subject of a separate bill. I think my goal here was to close this gap in the law and try to keep it clean. But you're right. To my knowledge, the fine, you could increase that. You could make it 5,000. You could make it 10,000. You could make it more.
Thank you.
Vice Chair Cost is going to remain the chair because I'll be kind of in and out this morning. So we'll let him just be the steady.
Thank you, Madam Chair. Senator French, you have a question?
Yeah, thank you, Vice Chair. Mr. Vice Chair, Representative Stith. So if they're juveniles and they create the image, they're 17, and then at 18 or whatever, they get mad at each other and split, and one of them does the revenge thing. Does this still apply, even though the images were created maybe when they were 17?
Mr. Vice Chairman.
Representative Stith.
Senator French, that's a great question. And I think the way the plain language reads is that because the relevant date is the date that you disseminate the image. So let's imagine you're 17 when you're all happy in your relationship, right? And you're sexting and you're under the sort of the sexting juvenile scheme, but then you turn 18 and then you split up. I think the bill as drafted seems to key off of when the dissemination occurs. When you're posting it on social media, for example.
Mr. Chairman, Representative Stith, Senator Kolb asked me a question about the fine in the bill and if that should be increased. And as I was thinking about that fine and thinking about the conversation concerning a civil cause of action as well, any thoughts about having a exact dollar amount for some type of restitution figure? Because in this case, I think it'd be very hard for a victim to receive restitution because they're not out any probably out-of-pocket costs. They don't have medical bills or any of those concerns. That would be something unique and different in the criminal code, like a liquidated damages provision type of a situation. Any thoughts about that?
Madam Chairwoman, I believe that would be an appropriate and perhaps creative way to approach it. You could add a restitution provision of this, again, by analogy to copyright law. Copyright has sort of minimum statutory damages that you can allege without having to prove actual damages. Because I think you're exactly right that in the case of dissemination of an intimate image without your consent, that how do you measure your sense of humiliation, or how do you measure the damage to the victim? So it could make sense. It would make it easier for the courts certainly to administer if, as part of the, let's imagine you have a plea bargain, right? Because if it's a misdemeanor, you're probably going to have some plea bargain where you plead guilty to this and you agree to be on probation or something and you pay a fine of X. It might make sense to have a statutory benchmark for restitution. I think that I would welcome that as a friendly amendment as well.
Representative Stiff, the question I have is kind of goes back to what Senator Cope was talking about. What about a tiered penalty for second, third offenses? I mean, I know you said that pretty much you're not opposed to that, but just wondering what your thoughts are.
Sure. Mr. Vice Chairman. Well, right now as drafted, you could commit the same offense 6 times, and every time it would be a misdemeanor. And you can imagine some frustration on the part of perhaps the prosecutor or the judge even, or the public, to say, here it is, this person's done this 5 times, and the most they get is a misdemeanor. I would regard it as a friendly amendment if you wanted to say, as we do, for example, for driving under the influence, you have all these gradations of second offense, it's this, and third offense, it's that. That's, for my mind, that would make some sense to do. Again, I didn't have the creativity or the energy to put it in the bill draft, but I think that would make good sense.
Senator French.
Thank you, Vice Chair. Representative, so they split up, they're 18 or older, and let's say the guy's really angry and he just sends that image out, and maybe he's been drinking or something, and hour later he does it again, just 6, 8 times, in his anger, and let's say he does it 6 times. Is that 6 separate events or classed as one event? Because it's Tuesday night and he's angry and he's under the influence of alcohol and he's just keeps doing it. Each time that is a separate event?
Representative Stiff.
Vice Chairman Cost, Senator French. Technically, yes. And I've seen prosecutors who will take what to me appears to be a regular, what could be for a volatile relationship, a typical Saturday night, and they will turn it into 8 different crimes that the person committed during the course of their altercation, for example. But I think technically, a creative prosecutor, and chairwoman can talk to her experience about that, but I think you could allege it as separate offenses, which, again, points to perhaps the, the caution about you don't want overkill on a statute either. Right. So maybe it makes sense to pass this bill as it is, see how it works, see if in society, if our prosecutors are having trouble because they've got these repeat offenders. It's your choice.
Follow up.
Thank you, Vice Chair, Representative. Yeah, and I understand the bumping it, and maybe second offenses, 12 months and $2,000 and just graduated scale. But at what point do you really, what the individual's done is wrong, totally wrong. But that one night of anger, potentially on a graduated scale, maybe they're looking at 5 years plus. And thoughts on that?
Representative Stiff.
Mr. Vice Chairman, Senator French, I think you're exactly right. And there's been the last several years, I think this committee and the legislature has worked to try to right size our justice system so that we're not creating more felons than we need to make sure that we're having punishment that's adequate to the crime, so that we focus on sending the right message in society, so that we get law and order, so that we get safe and secure society without having to overcrowd our prisons. So I think that I agree with you.
Senator Coe.
Thank you, Vice Chair. Representative Stith. On that issue about multiple images, it appears, by the way it's written, it's not more than 6 months. So I'd assume a judge that would probably be dealing with all these multiple accusations back to back would have the discretion to deal with it. Could be one day, who knows? But I think there has to be a price paid for folks that think they can just send out somebody's image and humiliate them and not have a consequence for that, because it is, I'm assuming, devastating to the person who had this happen to them, to them. And so I think there's discretion built into this. Thank you.
Madam Chair.
Mr. Chairman, Representative Stith, I just recently read an article about, I forgot what it's called, but the practice of taking someone's face and putting it on another person and displaying these types of sexual images. This bill doesn't address that particular type of conduct, does it?
Madam Chairwoman, I believe it does, because it doesn't make if a person privately manipulates a computerized image, that is not criminalized by this bill. So that conduct itself would not be a crime. But if it depicts, and if the resulting computerized image is an intimate image and then you disseminate it, then this bill, if adopted, would make that a misdemeanor. If that
Follow
makes
up,
sense.
Mr. Chairman.
Yes.
A couple things to focus in on, Representative Stith, which is on page 2, the definition of displaying sexual acts. And then in comparison to on line 16, intimate image. So when we look at displaying sexual acts, it means displaying an image of sexual acts regardless of whether a person's intimate parts are visible in the image. It's kind of a unique piece there. And then intimate image, the bottom of the page, means an image of a person's intimate parts or of a person engaging in sexual acts when the person depicted is identifiable from the image itself or from information displayed with or otherwise connected to the image. And so this, if an intimate image isn't required, help me understand whether or not an intimate image is required or not in order to be successfully prosecuted for this crime. And then do you think Romanet 4 covers that conduct of photoshopping someone's face into another type of image?
Madam Chairwoman, I believe going down to the elements of the crime, element 1 is that you must have disseminated an intimate image of another person. So you have to have an intimate image. Image includes the computer generated. So in the example, so I guess the question is whether the statute's overly broad or not. But it appears that as drafted, it would cover the situation where a person's face is put on Mickey Mouse and then you have Mickey Mouse engaged in some vulgar conduct, right? That would seem to be included in the definition of intimate image. And so that would be a crime. So
Mr. Chairman.
question is whether that's overly broad or not.
Madam Chair.
The term that's being used, I think, across the globe is called deepfake. So we should look at that and make sure that this bill addresses that conduct as well. And just evaluate that carefully.
Madam Chairwoman, I think, so for example, if it's deep fake, but it's not showing, intimate parts, it's not depicting some vulgar act, then it wouldn't be covered by this. That is, if I merely make a deep fake video of a person that purports to have them at a restaurant having dinner, when in fact it was not them, they were not at the restaurant, that's not where they were, that would not be covered by this because there's no intimate piece of it. But it would cover it if I were portraying them not only at the restaurant, but engaged in some, vulgar act, I think. So that's how it's drafted now.
Good.
Any other comments? Senator Cole.
Just a clarification at the moment, this amended document that we received, this is actually what came out of the House
That came out of the House,
So,
and
but
that's the
that's-
copy we're to use
today.
because that's been approved by the House. So that's the copy we use.
Mr. Chairman, for many of the new members, as a bill is worked through the legislature and through the other chamber, you always want to look for the engrossed version, which means the most current version. And so on the top right-hand corner, there'll be an ENG typically on the bill draft, and that means engrossed. But you'll be able to always see the original version of the bill, which is what we have in our packets. We have just been provided the engrossed version, which is what has been modified, and it is the most current version in front of you, and that's the version to work off of.
Madam Chair, I'm sorry, but there was no engrossed version in the file, and that's why they didn't get it in their packet. And that was my mistake for not noticing that wasn't the correct version.
Oh, no, thank you, Ms. Even. And this is common, and because we are working so fast and so efficiently that it's sometimes hard to keep up with all of the information and all of the most recent versions. And so not uncommon for this to occur, and always just something to be mindful of. And it's a common occurrence of which version of the bill are we working off of?
Senator Cole.
Well, then I have something more timely to ask. In the amended version, it is a felony, not a misdemeanor. And I guess to that end, Representative Stith, what is your opinion? Is that do you feel that you would like it to remain a felony? I mean, as the drafter of this bill, the one I have in front of me, the amended version, it is listed as a felony. I'll just read it if you want, if you need to, if you don't have it.
Madam Chairwoman, Senator Cole, the version I've got, that I've just got the electronic copy here, it says engrossed at the top. And it appears to me, it seems that in subsection C, it keeps it a misdemeanor. But perhaps for some reason, that's just the version I've got from LSO. So maybe I'm not working off the right version. I thought it was passed out as a misdemeanor. I didn't think we had a felony piece of it.
Mr. Chair,
Ms. Even?
this that you just passed out came from Joseph Barron.
Oh, that is public testimony that we'll probably hear on the bill. He is a prosecuting attorney up in Crook County. Those are probably his recommendations.
Those are his recommendations.
Great. So
Okay.
let's take a brief break, a few-minute break, and we will print off the engrossed version for the members. I have it online as well, and we'll work off that bill. Stay close, Representative Stith. And maybe what we might do, Just just some 4 copies or so.
That's my gross copy.
But with that, we may just go ahead and proceed with public comment on the bill, for the efficiency of time. So is there anyone in the room that would like to speak on the bill? Yes, please come forward.
Mr. Chairman, members of the committee. My name is Laura Lewis, and I'm here this morning on behalf of the Motion Picture Association. And very briefly, we just stand in support of the House committee amendment, specifically to include the intent to harm, harass, threaten, or coerce language. The reason being, there are times when legitimate news organizations need to disseminate or publish sensitive images that include nudity for educational or historical value. Think back to images from the Holocaust or Pulitzer Prize winning Napalm Girl. In those circumstances, this intent to harm language is very important to just really make very clear that those kind of circumstances are not intended to violate this law. And it has been challenged in other states, I think, as the bill sponsor mentioned. So that's our interest in keeping that language in the bill. With that, I stand for questions.
Any questions? Any questions?
Thank you.
Okay, seeing none. Thank you very much. Is there anybody else in here that wants to testify on this? Not hearing that. We do have some that have their hands raised online. If we will let Mr. Barron in and let him present his testimony, please. Mr. Barron, we see that you're there. If you will turn on your video and take it away.
There it is. Oh, my name is Joe Barron. I'm the Crook County and prosecuting attorney. And today I'm here on behalf of myself as county attorney. I've submitted a couple, a document there with my proposed changes. And these changes are essentially, when this bill was started, it was a misdemeanor offense. And then specific intent language was added to that bill. And so what my general proposal is to have a misdemeanor and to have a felony aspect to this. Recently, this committee heard compelling testimony on the voyeurism bill. And to me, just listening to that, and that's, as you recall, the one guy was taking pictures in the bathroom with a hidden camera, and the other one was taking pictures underneath somebody's dress with his cell phone. And here it looks like this particular conduct that we're talking about here is actually more heinous than that. That all of it's bad, but this is worse because in those cases it was just going to one person, and in this case it's going to the world. And so because once it's out there, we all know, and it's out there on the internet, it tends to live forever, and it tends to get disseminated widely. And so my proposal is this, in essence, is that you make this a similar penalty with if you leave it the way it is in the engrossed matter, with the intent, the specific intent version of that you make that a felony, because remember, the same as you did with the voyeurism bill. And then you also you go back, and even, I recommend even further back than the original bill draft, and make that general intent crime a misdemeanor. And what I mean by that is that generally in the laws that the legislature passed and that I prosecute, the more specific the intent is, or the more the harm is intended, the more aggravated the crime is. And so a general intent crime is one where you know you're doing something wrong, but you're really not intending to harm somebody. And what we're talking about here is pretty egregious conduct. I don't think it doesn't have anything to do whatsoever with the First Amendment. We're talking about here is disseminating images, intimate images, without somebody's permission. And nobody should have to deal with that. Doesn't have anything to do with making movies, doesn't have anything to do with your right of free speech, doesn't have anything to do with naked people that under the definitions in this particular statute. It's more grievous. So what I had proposed in this particular bill was essentially to go back to the original language for the misdemeanor, getting rid of the language on, as you see there on page 4, is just requiring 2 things. The person is guilty of the offense of disseminating the intimate image of the person if they disseminated the image, and the depicted person did not expressly give consent to the image's dissemination. That should be enough for a misdemeanor offense. The second thing on that would be then I would add a subsection D on page 4, line 22. I don't know how you do that where there's a whole bunch of lines there, but I would just add this and say, is that offense of disseminating an intimate image with intent to harm or sexual gratification if you do all those things that were set forth on the House floor that added to the original bill in this particular matter. So the first offense would be a misdemeanor. The second offense would be a felony that would be equal to the felony provision that this committee added to the voyeurism bill on that. And then the other thing that I added on page 5, line 7 would be to add this particular thing, is that it would be an affirmative defense if the depicted person expressly consented to the dissemination of the depicted image, or that the depicted image was not to remain private. And so if a defendant claimed that offense, then they would have to raise that issue in the matter rather than the state having to do that in the misdemeanor case. In the felony case, we have to do that, but in the misdemeanor case, it would shift that over to the defendant. In closing on this, I believe the conduct here is more egregious than that in the voyeurism bill. And I think that there's a reason to treat it as such. Thank you.
Any questions for Mr. Bourne? Barron? You have some? Senator Cole.
Thank you, Vice Chairman. Mr. Barron, I know. Hope all goes well today. The question is time between images. So we talked about a misdemeanor to a felony. Is there some sort of reasonable time period, or could it be just one after the other of dissemination would make the second one a felony? Could you elaborate on that? Thank you.
Sorry, Mr. Barron.
Mr. Chairman, Senator Cole, in this particular case, the way that it exists right now, the statute that exists in the engrossed version, and also the proposed changes that I have, it does not address the issue of multiple photos. So what that would mean is that for every photo, it would be a crime, okay? So if you did 10, there would be 10 misdemeanors or whatever. Now, as a prosecutor, what I would look to in this particular case, you know, if there's one photograph, that's it. But I would think that in trying to prove that intent to harm, humiliate, harass, threaten, or coerce, and I would look to that as to multiple times of doing that would go to show what that specific intent of what was going on there, and that it wasn't just a mistake or an accident or anything like that, that this was specifically intended when you sit there and did a whole bunch of them, even over a course of conduct or a period of time. And so I think that multiple images might be used to prove that, and just looking at that issue. You could also change the law or add it and just say, you know, we have that in other statutes where you have a course of conduct, or you kind of get to merge things together, like on, not really relevant, but say bad checks. If over a course of time, the amount goes over $1,000, then you can merge those all together to make a whole bunch of misdemeanors into a felony case on that, because you reach the threshold limit on that.
Okay. Other comments? No other comments? Okay. Well, thank you very much for your testimony, Mr. Brennan, and we'll see if there's any reference back to you in a minute, okay?
Okay, I will stand by. Thank you,
Thank you.
Mr. Chairman.
I see that Mrs. Muir is up. There she is. Take it away.
Good morning, Senator Cost and members of the Judiciary. I didn't hear a word you said as I was coming over the twilight zone, so I think I'm called on. My name is Tara Muir. I'm the Public Policy Director for the Wyoming Coalition Against Domestic Violence and Sexual Assault. I represent our community-based nonprofit programs across the state who serve survivors through crisis lines, counseling, court accompaniment, shelter, and whatever their needs are. We're beside them all the way. We are here to support Senate File 85. I want to thank Representative Stith for bringing it. It's a really good big bill, not even a little bill. It's a big bill, as County Attorney Barron was referencing. Victims have long needed help to stop this kind of behavior that's been happening in our state. We hear stories almost every day about these kinds of videos and images. There was one domestic violence survivor, I don't think anyone, maybe one of you was on this community, when she talked about she was forced to participate in a film of her having sex with other people, not her boyfriend. And then it was used to keep her in that relationship by that boyfriend for a long time because of the threats to disseminate it. Of course, then there are the victims who do have those images shared. Please know that sexual assault, domestic violence exists on a continuum of behaviors, from what seems like innocent bad boy behavior, like peeking under someone's skirt on one end, to rape and murder on the other. And they're all connected along the continuum. How early we intervene and stop this bad behavior is important, and this bill will help do that. We support the bill. As originally written, we supported it because it did not have on page 4 the intent language in there. But I like where this is going, that we'll bump it up to a felony when we can prove that intent of harm or sexual gratification that Barron was talking about. The case that went before the Minnesota Supreme Court had a very similar structure. No intent was needed for the misdemeanor level. Intent was needed if you were going to bump it up to a felony. I'm trying to skip some of this. There are model bills and there are national organizations who this is their only focus. There is a cyber civil rights initiative. Their model bill does not require intent at all. I think their basic model bill. Just a couple of points I want to make, and then I can be done and stand for questions. I know we're eating up time. I want to be clear. The other piece, before I kind of do those talking points, is the Minnesota bill, and I think even the Vermont bill that Minnesota was talking about as well, had a list of exceptions. And one of them was for the media, or where's my highlighted piece? The Minnesota statute had a list of 7 exceptions. One of them, images related to a matter of public interest and dissemination serves a lawful public purpose, which I think would apply to the examples the previous speaker had. Other exceptions are criminal investigation or prosecution, reporting unlawful conduct, seeking or receiving medical or mental health treatment. There was a list of exceptions that maybe at some point we can look at. What I wanted to hit on is that this is not really a free speech issue. This is about privacy and sexual privacy, which all you have to do is jump on that darn internet and understand that so many women do not have sexual privacy. And this is what the case is really, or the bill and the Minnesota case really turned on. And some of the research, social scientists say people disclose these private, intimate images of others without consent for a myriad of impersonal reasons. They're not just mad one night about an ex-girlfriend. It can be a desire to gain social status, to make money, of course, for sexual gratification, or just to provide entertainment. The harm that's here is denying people the ability to decide for themselves who sees their naked bodies. It would attest to the serious harm to your dignity of being reduced to sexualized body parts. And that's what these crimes are about. This makes clear how invasions of sexual privacy threaten equality, given the stigma that many women, people of color, are often targeted in these kinds of images. It's also recognizing in these ex-boyfriend, ex-girlfriend examples, the profound betrayal of trust and damage to future intimacy when these pornographic images, while maybe have started consensual, certainly weren't when they were shared. And that's the information I wanted to give you. I, again, support County Attorney Barron's amendments. I don't know if we need, he mentioned, and I don't have the written amendment in front of me, a subsection E on page 5, that there would be some affirmative defense. Y'all know better than I how that all works, but it sure seems like in our definition of what is new or should have known, the person had a reasonable expectation that it would remain private, and that person did not expressly give consent for the image's dissemination would clearly be within that definition. That has to be proved before you can even go forward with a misdemeanor, let alone felony. Thank you for your time this morning, and I'm happy to take any questions.
Thank you. Are there any questions? No questions. Is there anybody else? Okay, we have Mr. Byron Odekoven. Can we let him in? Mr. Odekoven, we see you're there. If you will start your video and take it away.
Thank you, Mr. Chairman. Thank you for allowing me to slip in this morning via the internet, which I hope the internet speed keeps up. We were having difficulties with it the other day, but hopefully it allows for comment. Quickly, Byron Odekoven, the Executive Director for the Wyoming Sheriffs and Chiefs, rising in support of the bill. This is one of those friends to the legislature, if you will, that we've looked at for the last several years, trying to wrestle with the proper format to have a bill. And I would like to capitalize on it from the standpoint of looking out for the victim, and to hopefully have somewhat of a chilling effect on those who might perpetrate this crime on those victims. It's very difficult for us as being the responding person to these type of calls and to be sensitive to the issues, only to look the victim in the eye and go, yes, that's wrong. No, they won't be going to jail. That's difficult. And I think this bill provides that opportunity to clarify the standard of conduct in Wyoming for those victims and to send a message clearly to those who would use this to their advantage that it will not be tolerated in Wyoming. I appreciate the discussion this morning, especially from the standpoint of enhancing this from the misdemeanor, if you will, without the intent, that lesser offense, and escalating it to the more serious offense, which could in fact be a felony. And I realize the legislature's reluctance to create additional felonies, but I would hope that that reluctance is also tempered in some of these cases where there's very egregious behavior. The county attorney's discretion comes first and foremost on how those cases would be presented and prosecuted. And as we've already discussed, they do a great job in exercising that level of discretion. Mr. Chairman, with that, again, supporting the bill, enjoying the discussion, and answer any questions.
Are there any questions for Mr. Odicott? Okay, hearing no questions there. Thank you very much, sir. Pleasure to hear you.
Thank you.
Are there any others out there? I don't see any other hands up. If there are no hands, we will be closing. I'll give you a couple seconds here. Okay, not seeing any hands. Is there any in here? Okay, we'll close that and have Representative Stiff come forward for final comments.
Mr. Vice Chairman, thank you. Just a couple of comments for Mr. Barron's proposed amendment. I'd like to address that just briefly. So if you created a felony, that's sort of just your choice on what level of punishment you want. The First Amendment concerns, though, are not frivolous. Okay, one of the advantages of the current draft in front of you is that by having the intent element, you make it bulletproof from attack. And why is there a First Amendment concern? There's a First Amendment concern because this would be a content-based restriction on speech. Okay, and if you have a content-based restriction on speech, then it triggers what's called strict scrutiny under the law, which means that when a court looks at it, you have to show that the statute is achieving a compelling state interest and that the statute is narrowly tailored to do that by the least restrictive means. Okay, so the intent element helps a lot with that. In the Minnesota case that upheld it, the intent, the fact that you've got this intent to harm makes it clear that it's not protected speech. So I like the current draft because I think it's bulletproof from constitutional attack. Now, you could adopt Mr. Barron's amendment. I mean, his proposed amendment's not irrational. It's not out of the ballpark or anything. You could certainly do it that way. And you could have a misdemeanor essentially without the intent element and a felony with the intent element. You could do that. If you do that, however, if you have a misdemeanor version of this that doesn't require the intent to harass or harm, then I think you can't just have this amendment. You also have to create a laundry list of exceptions, okay? Because think of it from a practical point of view. If you're the police officer responding to the scene, well, the victim is going to give you a copy of the image, right? And then you're going to have to get that image to the prosecutor. The prosecutor is going to have to give it to the defense counsel. So you have all these people in the chain who will be disseminating the intimate image. And obviously, we don't want to say that the police officer or the prosecutor is committing a crime in doing so. But if you take out the intent element, then they are committing a crime, right? So if you want to take out the intent element and make that the misdemeanor and then have intent and make it a felony, as Mr. Barron proposes, that's okay. I mean, that's not that's a reasonable thing to do, potentially, your choice. But if you do that, then you've got to create a laundry list of exceptions, okay? And that's where it gets complicated, right? Because what are all the exceptions, right? It's, Minnesota has like 8 or 9 of them. One is for educational purposes, which frankly, I don't understand. Okay. And my problem with creating the exceptions is that you don't want a blanket exception for law enforcement, right? Because although law enforcement and the prosecutors have to legitimately handle the images, you don't want them, using it for entertainment purposes, right? There was a case in Salt Lake in the last couple of years where you had a very tragic case, frankly, where you had this person who was being victimized and her intimate image was evidence, and the police officers were just sort of passing it around the office for fun, right? And it was sort of just a kind of an ugly, tragic incident. So long story short, your choice if you want to adopt Mr. Barron's amendment. It's not irrational to do so. But if you do so, you can't just adopt that amendment. I think you have to also add in some exceptions so you don't sweep in, conduct that you don't want to criminalize. So on balance, I kind of like the draft the way it is. It's clean. You don't need the exceptions for law enforcement or for the county attorney if you've got the intent to harass element, because obviously if the officer's just doing his job, he's not intending to harass, he's trying to prosecute. So.
Senator French.
Thank you, Mr. Vice Chair. Representative, I'm not an attorney, so bear with me. So it sounds like you're happy with it. Would you be happy if there was an amendment on page 4 on 18 through 21, the punishable part of it? Currently it's 6 months, not more than 6 months. If there was an amendment that said for a second offense, it would be up to 3 years and $10,000 fine. Does that destroy the intent of your bill? It just kind of adds another layer. You do it a second time and it's ratcheted up big time here.
Mr. Vice Chairman, Senator French, that would be a reasonable amendment to me, because I think there is a difference between someone who does it on a one-off basis and someone who's doing it on a serial, multiple basis.
Other comments? No. One question I was going to ask is, with Mr. Barron's, if we left intent up on the original first part as well, would that complicate matters or would not help it in any way?
Mr. Vice Chairman, I believe if you leave the intent element in as is, then there's no difference between the elements for a misdemeanor or for a felony, right? And so, your choice. You could just say, we disapprove of this so severely, we think it should always be a felony, even for a first time. In my view, that's a bit overkill, but so, right. I think the elements would be the same then. So thank you.
Okay, thank you. Any other questions? Okay, with that, we'll close public testimony. What's your wishes?
Move the bill.
Move the bill? Do I have a second?
Second.
All right, it's been moved by Senator Cooper and been seconded by Senator Kolb. Is there discussion? Senator Cooper.
Mr. Chairman, the bill as it is in the gross copy, I think is a very clean bill. It's very precise. If we start hanging a lot of amendments on there, we're going to muddy the waters quite a bit. I think it's a very necessary bill, and if we find issues with it at some point in the future, we can always amend it, but I think it does exactly what we're looking for right now. If we wanted to step up for a second offense, I wouldn't have a problem with that, but I think it does what we need to do for right now. It's a great place to start, and it's clean, it's precise. It's probably exactly what we need to start. Thank you.
Okay, thank you, Senator Cooper. Senator Kolb.
I'd like to make an amendment.
Okay, what's your amendment?
Page 4, line 20. Change $1,000 to $5,000. And also, I'm sorry, backwards. Line 19, change 6 months to 1 year.
Okay, so if I'm understanding you correctly, you're saying on line 19, change 6 months to 1 year. And on line 20, change 1,000 to 5,000.
Yes.
And then on line 21, the write-in of 5,000.
Yes.
Okay, did you get that? Okay. Senator French.
Thank you, Mr. Vice Chair. To clarify, is that for a second offense or the initial first offense?
As written as the initial first offense, it's discretionary. It's discretion. The discretion is up to the judge. But for the first offense as written. So it's cleaner. I think it's simple. Yes, we could do a lot of things, I think, with amendments to stiffen it up for, say, a second offense, or change to some other recommended language, but it would have a lot more language probably have to be discussed and talked about. So I thought this might be a simple way to up it and then, proceed forward with it as a first way of enhancing some of these penalties.
Okay. Any other thoughts on it? Board Senator French.
Yeah. I want to add an amendment, but do we vote on this one first, Mr.
Yeah,
Chair?
we would vote on this amendment, and then you're certainly welcome to add another amendment. Senator Cooper, did you have something to say? Okay. Is there any other discussion on the amendment? I would need a second for us to move on. Okay, it's been seconded, moved by Senator Cope, seconded by Senator French. The amendment, as we, excuse me, is to replace line 19, the 6 months with 1 year, and on line 20, change it to 5,000, and on 21, make it 5,000. All those in favor, aye?
Aye.
Opposed? No? Motion carries. Okay, Senator French, you had a suggestion for another amendment.
Yes, I would like to add in on line 18, after image, add a second time. So it would read dissemination of an intimate image a second time is a misdemeanor punishable by not more than 3 years. And then and continuing on 21, fine $10,000.
Okay, I believe that what we would have to do there is break it into Romanet I and Romanet II, where Romanet I would be the single offense, and Romanet II would be the second offense. But it will let LSO take care of that.
Okay.
So basically to make sure that I'm clear on it, what you're wanting to do is say a second offense. Do you want to say second offense or more, or just second offense would be up to?
Second offense or more.
Okay. So the current amendment would be to add a second offense, 3 years, excuse me, $10,000 fine, or both. Is that correct? Okay. Is there a second first? Seconded by Senator Cope. Do you have that? So it would be underneath. Let's go down below line 21 and just write this so that they can add it in.
Would this be a D? Or
I
would
think
you have a Romanet I and a Romanet II?
it might be a D, but it might also, yeah, but I'm thinking they might have to break Romanet C into 2 parts, but I'm not sure. You can
Okay.
put it as a D right now.
And they'll change
LSO
it
will
if they
probably
need
say,
to.
you
Okay.
can say D or Romanet 2.
Okay, so dissemination of an intimate image for a
Second offense
for
or more.
for a second time or more.
Yes.
Okay.
And then it would read
Is
a felony.
felony.
Or do you want misdemeanor? Okay, so he's going to
Okay.
leave it as misdemeanor. So is a
Okay.
misdemeanor.
Or more
Or
is a
more.
misdemeanor punishable by not more than, you're
3
changing
years.
that to 3 years
A fine of not more than 10,000
and 10,000.
or both.
Or-
Representative Stith.
crime is punishable by more than 1 year,
It's felony.
it's a felony. So you don't have to call it one or the other. You say penalty is.
And I was going to say LSO will straighten it out then, right?
So do
Okay.
I need to change that to felony in the second one? Okay.
Yes. You still okay with your amendment? Is there any more discussion on that? All those in favor, aye? All those opposed, no? Motion carries. So we have the two amendments. Are there any other amendments? Hearing none, let us take a roll call vote.
Senator Cooper,
Aye.
Senator French,
Aye.
Senator Cole,
Aye.
Senator Cost.
Aye.
Do you want to leave it open for Chairman Nethercott?
We'll leave it open for Chairman Nethercott, please.
So, Mr. Vice Chairman, House Bill 85 engrossed passed as amended.
Thank you. Okay. We're going to see if the next one will go a little quicker, hopefully. If we could have Representative Stith come up for House Bill 46. This one does not show engrossed, so I'm assuming there were no amendments to it or anything. To be perfectly honest, I don't know how you can say very much to it. So bottom line, crime of bestiality. Representative Stith, take it away.
Mr. Vice Chairman, I present to you House Bill 46. Ask for your favorable consideration. The definitions show up on page 1. It's a one-page bill. Wyoming is one of 4 states in the United States that does not have a law that outlaws bestiality. It's not that I would necessarily regard it as a widespread or growing problem, but in my county, we did have an incident last year where the matter was investigated. It was actually on video. There was really no question about the facts of the event. Law enforcement investigated it. They were able to prosecute for trespass, but were not able to do anything more. And the community, I think, sort of felt that trespass didn't quite capture the justice in that matter. So again, this is drawn, I tried to make this, again, a pretty plain, simple bill. It does create some exceptions on subsection D for normal, ordinary, or accepted practices involved in animal husbandry, artificial insemination, or veterinary medicine. And with respect to the penalty, it makes it a misdemeanor, punishable by imprisonment for not more than 1 year, fined of not more than $1,000, or both. And again, I just, for the same policy reasons, I didn't think it was a widespread problem that we need to create a new felony for. But your choice on that, how you feel about it. So I would stand for questions.
Are there any questions for Representative Stith? It looks like we're pretty quiet up here. Is there anybody that would like to testify out there on this bill? Representatives one, it's a pleasure to see you today.
Well, thank you, Senator Costa, members of Judiciary. We're going to be hanging out a lot in the interim, apparently.
That's what it sounds like.
And certainly here for the next bill, but as doing animal work here in our statutes for about 14 years, I would be one of those people who would request it be a felony offense, maybe on a second or subsequent charge. So, the good bringer of the bill, I think, has taken the first step. But when you look at other states who have similar laws in place, other states have different classes of felony. But perhaps in this case, it would be appropriate if there was a second or subsequent conviction to make it a felony level offense. Other states, it triggers a whole lot of other statutes on if you have to be a registered sex offender and some other things with a felony conviction. So I would think at least on a second or subsequent offense, a felony might be warranted. That'd be my only testimony. I hope you support the bill.
Thank you. Is there any questions for Representatives Wanted? No? Okay, thank you. We have at least one hand up out there in the other world. On the online, would Ms. Creech, would you please let in Tara Muir and we'll let her speak. Tara, as soon as your video comes on. There you go. Have at it, Tara.
Thank you. Again, good morning, committee members. We support this bill. Whether it's a felony or a misdemeanor isn't an issue for us. It's been needed for a long time. What is not in this bill is what victims need. And given the last bill's conversation and intent is still in there, we'll never prosecute hardly ever under that last bill. So when we try and speak up for victims, it's to help them get justice. So what we also know with victims in this state, sometimes they are forced into having sex with an animal and it's videoed, and that is held against them to coerce them into staying either in relationships or just to get them to do a whole host of things. So I haven't been able to find the perfect language yet, but I would like to have someone amend this bill to include an affirmative defense that someone was coerced into doing this. Because I think it happens more than we know. So that's food for thought. And as we continue discussion, hopefully I can email you some good language at this point. Working so hard on intent on the last bill, I didn't get that done. Happy to take any questions.
Okay, well, Mrs. Mayor, if we were to say, why don't you consider that maybe on second reading or so, so there's a little more time, would that be more reasonable?
That'd be beautiful.
Okay, members, are you okay with her possibly giving us something and we can decide whether we want it at that time or not? Rather than trying to do something right now and not have it right. You okay with that? Okay. Do we have any more questions for Ms. Muir? None, hearing none. Thank you very much, and hang in there a little bit and we'll see if we have to come back to you. I don't know whether we will or not. Mr. Odekoven is in there. Ms. Creech, if you would allow him to come forward. Mr. Odekoven, we welcome you back.
Thank you, Mr. Chairman. Again, Byron Odekoven, representing the Wyoming Association of Sheriffs and Chiefs of Police. One quick comment in support of the bill, I might add, and that it is this act was brought out of a specific event, if you will, in Sweetwater County. But unfortunately, I can tell you that it happens across the state. And I could share some interesting stories that would not necessarily be appropriate as well. But nonetheless, suffice it to say that this does indeed happen. It happens more frequently than we would like to believe. And there's lots of nuances that we could spend a considerable amount of time on and visiting with as it relates to the perpetrator or those that would engage in this kind of activity. So I think we'll save that for another day, deal with the bill that we have before you, and suggest favorable consideration and passage of this bill, Mr. Chairman.
Are there any questions for Mr. Odekoven? There are none. Well, thank you very much, and stand by and we'll see where we go. Mr. Barron is needed into the room. Would you please bring him in? Okay, Mr. Barron, I think you're hopefully live with us. It looks like we don't have your video quite yet, but there should be. There you go. Welcome, and what do you have to tell us?
Thank you. Joe Barron, Crook County and Prosecuting Attorney on behalf of the Crook County Attorney's Office. I stand in support of this particular bill. I would agree with Ms. Muir with her proposal on that, and would be willing to help her to work on that and get something back to you on that. So that could be, those victims can be protected.
Okay, and members, any questions? All right, I would ask that maybe the two of you can get together. If you need an email, I could certainly send you and work out something that maybe we could bring to Second Amendment or Committee of the Whole when it's brought forward. So depending on the time, we'd like to make sure that Representative Stith is aware of it and can give us feedback as well. We appreciate your help on this and getting it right, because that's the important part, is so that we can get something right. Is there anybody else out there? Anybody else? Going once, going twice? Okay, with that, there's nobody in here that's still interested in testifying. So I will close testimony from the public and ask members, what's your wish?
Move the bill.
Okay, it's been moved. Is there a second? It's been moved by Mr. Kolb and seconded by Mr. French. Any suggestions? Amendments, discussion, page 1, page 2. Senator Kolb.
Oh, comment is on that. I think I'd look forward to proposed amendments that are going to be welcome, well-written. I think it's, we don't have the time. I think I look forward, though, to seeing what is proposed by the other advocates of the support of this bill. Thank you.
Very good. I also agree with that. Anybody else? Are we ready for the vote? Hearing none, let's take a roll call vote.
Senator Cooper,
Aye.
Senator French,
Aye.
Senator Kolb,
Aye.
Senator Cost,
Aye.
and we'll leave it open for Chairman Nethercott.
Oh, yes, we will.
Okay.
She's got to have her name on there too.
All right.
Very good.
So, Mr. Vice Chairman, Chairman, the House Bill 46 passes with 4 ayes and 1 open.
Thank you very much. Okay, with that, we're going to move on to our next bill, which is House Bill 103, Journalist Privilege Communications. And Representative Zwanitzer, it's good to have you back with us.
Good to
Take it
be here,
away.
Senator Cost. Well, good morning, members of the Judiciary Committee. I think this is my first time officially appearing before you this session, and haven't got to meet many of you, at least as legislators. I know some of you from my former life. But happy to present House Bill 103, known as Journalist Privilege Communications, commonly known as SHIELD Law, as you'll hear several people testify today. And so SHIELD Law is basically any law that protects journalists against disclosing confidential information, either the identity of who has provided that information or any unpublished written material that was given to a journalist that they've used during news gathering. So 2 main justifications, right, in the country for SHIELD laws. First is, I feel really loud, individuals are more likely to provide confidential or sensitive information if they know their anonymity can be protected. And I mean, that's just a good journalism practice and beneficial to the existence of a free press in our society under the First Amendment. The second really comes when it comes to subpoenas, right? That subpoenas can demand information from journalists, and currently under Wyoming law, they would have to be executed, right? So you say, hey, who provided that information? Under Wyoming law, we don't have a SHIELD law. We're one of only 2 states. Currently does not have that protection in place for journalists. So 48 states have some form of a SHIELD law. Our neighbors to the east in Nebraska actually wrote it into their constitution. They thought it was so important back when they became a state. There was and just so you know, the kind of the background for the last 50 years, there was a Supreme Court case, 1972, called Brandenburg. It was a 5-4 decision that there wasn't ultimately a federal law to provide a shield for journalists under the First Amendment. So after that went down in a 5-4 decision, states started pretty immediately, actually in the 70s, passing shield laws. And you'll hear some instances that there have been issues in Wyoming the past 15 years, but really it's just kind of, we're the last state on the continental US that doesn't have it, us and Hawaii, and we're always that kind of black state. And I think in a state like Wyoming, when we are so small and we have so few journalists and everybody knows everybody, it makes it really important in a state like Wyoming that if you know something bad's going on, corruption, malfeasance, it's really tough in small towns to talk about that. But if you can maintain or guarantee your anonymity in reporting that information and get it out, I think that's ultimately what we're looking at, is making sure the information gets out about something negative going on, where people feel comfortable disclosing that for, accountability for government, corporations, whoever it may be, and transparency. Just walking you through the bill, I know it's pretty simple, but it basically says that if current or former journalist basically has this privilege that they don't have to disclose a confidential source of information, either the identity of a person or material that's given to them. And then I would say hate to say weakened, but we modified it in the House as a lot of conversations took place on narrowing the focus. We provided a burden of proof on the journalist. And you'll hear from journalists today, they don't take this lightly. It's not like everybody just gets, immunity and confidentiality. It's only in the most dire situations. And so we did do some exemptions. So if there was an imminent risk of death, journalists had what we call the bomb scenario. If they knew some harm was going to occur in the immediate future, you can't withhold that information in any defamation action. And then we quantified the defamation action really depending on what the situation was. So give some latitude to a subpoena to a jury if it was to reach that point. A defamation action against a public official is a much different standard than a defamation action against a standard individual on the street. So we had a waiver if the journalist voluntarily wanted to disclose at any time, then the privilege goes away. And then the House felt it best to actually include the definition of journalist. And there's a lot of different definitions out there. We went to both Colorado and Maine because 48 states have this in some way, shape, or form. They define journalist there. You'll see in the definitions 112.707. And it's fairly expansive on what a journalist is, but it really comes down to who's professionally engaged, right? Everybody who's a media blogger might claim to be a journalist, but there has to be some type of professional affiliation with an agency, with a newspaper, with a broadcasting association. We also included the University of Wyoming or community colleges. And then we further, you'll see in the bill, anyone associated with that journalist keeps that protection, right? So you're the writer of the story, you have the protection on your source, but your editor probably knows who that source is. Your editor has that protection, the board of the newspaper, right? The advisor of the college student, so that immunity in these cases, maybe it was people, the newspaper, they saw a certain legislator walk in the day before, and then a big news story breaks the next day. That privilege extends to anyone who might know the identity of the source. And then we had the word information in, so you'll see we have a definition to ensure it's news information, because we didn't want to put a definition of what information was in statute. So we just quantified that down to news information and changed information to news information throughout the bill. And then we just updated the rules of civil procedure there at the end, and it's effective July 1st. Be happy to sit for any questions, Mr. Chairman.
Any questions? Senator Cole.
Thank you, Acting Chairman. Representative, I had a few questions.
Sure.
First, I guess I've heard a lot about this lately, is that federal law trumps state law. So if there is in fact a federal law in place, why in fact is this really needed, if that's the truth? Thank you.
Senator Cost to Senator Kolb, I don't believe there is a federal law in place. It was a Supreme Court decision that went 4 or 5 the other way that said there shall not be, there's no federal qualified immunity. It's not really constitution. There's no protection in the Constitution. This is really a states' rights issue. If states want to protect their journalists, it was a 1972 case. And so since then, states have taken this on voluntarily, state by state. They're currently, I think they have had 3 attempts, and there are a lot of journalists I know who want to testify, 3 attempts at a federal law, but the Supreme Court said you shouldn't have a federal law in this realm. It's a states' rights issue.
Senator French.
Thank you, Mr. Vice Chair. Representative, is there anything in here that, is there any penalties for journalists who report something that turns out to be false? They falsely reported something. Are there penalties, fines, anything, any repercussions for doing something like that?
Representative?
Mr. Chairman, Senator French, not in this bill, but there are, I mean, if you report misinformation, any individual or entity could bring a civil action against the broadcaster, the newspaper, other places in Wyoming state law. We did put the burden of proof as we amended it through the House on the journalist. So if somebody comes after the journalist for withholding who the source is, the journalist would go before the court and have the burden of proof of saying why they need the privilege and establishing that. So but there's nothing in this bill that would deal with false information being out there. It would be interesting if a journalist, said this is a source and then made it up. They would go before the court, and I would assume there would be severe penalties in the court's discretion if, a defamation action certainly could be had.
Senator Cooper.
Thank you, Mr. Chairman. Representative, could you tell me the difference between information and news information?
Mr. Chairman, Senator Cooper. Not necessarily news information, I guess. It's a quantifiable term in a subpoena in a jury trial of what is news and what's fabrication, what might be made up. When the original bill just had the word information, and the committee chairman, Judiciary in the House said that was too broad. We didn't want to just define what information was throughout the Wyoming statutes. So we basically took the same definition and just put news in front of it to not interfere with any of our other Wyoming statutes when it talks about information. And so this is just, and it's specific to Article 7, you'll see. So it was just kind of a sideboard and defining the term a little better, that it's not any information that has to be newsworthy. It can't be salacious gossip. What we're really working on is professional journalists who are engaged in providing news to the public. So this doesn't cover, some of those websites who are all about, I would call it gossip or rumor. These are reputable places providing reputable news, and that's why we've defined journalist and this privilege somewhat narrowly. We've tried diligently to newspapers, magazines, news medias, associations that have professional components where people are paid, and this is, they've gone to higher education to invest themselves in this line of work. It has been an issue and through all of the states who've defined this on who is a journalist, who isn't, what is news information, what is rumor and innuendo. And so we tried to take the best of the 48 states who have statutes, case law, constitutionality, things written in their constitution, and said, this is as good as we're going to get in defining these things.
Okay.
Thank you.
Okay. Senator Cole.
Thank you, Mr. Vice Chair. A question about journalists, I suppose. So, I personally, I don't have any, I think it's the right thing to do to have confidentiality. The issue I think, though, is out there is, what do you do with the ones that don't offer, I don't know, they're politically motivated. They have other things they're up to that, don't hold up to the golden standard that you present as everyone would have. So then what do we do? I guess the first question would be are there other states that have penalties, direct penalties for journalists that violate, besides they're in some other statute directly in this, would other states have regulations that have direct penalties? That's the first question. I think there has to be something done. Unfortunately, the world of journalism seems to be getting more and more contaminated with pundits than news, and it becomes, like I say, the Inquirer. Well, shouldn't probably say that, but some sort of something to get readership, without being truthful. And I am concerned that I would think that we should have some sort of repercussions directly for the violation of these, your abilities that you're given. And they are special, and they are, to be protected for good cause and good reason. But what can we do to stop, let's say, the folks that maybe you would say don't measure up to a professional journalism standard? what can we do to protect the victims of said, I know there's slander, but what can we do to kind of clean it up maybe and make everyone responsible at some level at the table? I guess that's probably what I'm trying to get at. How can we make everybody have a little skin in this game to make sure that what they're doing is in the best interest and for the legitimate purpose? Thank you.
Representative.
No, Senator, they're great questions. And I'm not aware of necessarily criminal penalties we have. It's really the course of a civil action for slander, libel. I'm not aware, and there are some journalists on the line who tell you there are criminal penalties in other states for providing false or misleading information. You know, and I mean, this bill is pretty narrowly tailored that if you have some truthful thing about what's going on in a corporation or any kind of large entity where you're going to take this kind of action, where you're going to, put information out there that is damaging. The testimony and the thought, at least in the House, was, there are those internet sites that might throw that out, but if you're going to, any reputable source that does that, and you might, get a court challenge, if you're even a freelance journalist, you're going to go run to a major broadcasting network or newspaper to say, help me out here. I have some information and we need to put it out there, but they're going to, crucify me if I don't have some protection. And so the world is changing and everybody wants to be putting out breaking news. And is it really news these days? I don't know. But I know you'll hear some testimony that when a newspaper or a TV station or someone we'd like to consider legitimate as a news source still, and I know they're decreasing, does this and has information that they get protected and they can't be sent to jail or contempt of court for trying to get information out there to hold government or corporations or whoever it is accountable. But it's a much larger problem that I don't think is addressed in this bill. And if I knew the answer, I would be working on it.
Okay, and I'm going to remind everybody, time is running short, so we're going to need to try to wrap up a little quicker, okay? You have a follow-up?
No, Mr. Vice Chair, I'll respect the time constraints.
Okay, thank you.
I do have one brief question.
Okay, Senator Cooper.
Thank you, Mr. Chairman. Representative, I don't see definitions in here as is really needed. I don't see a definition of a journalist. I don't see a definition of news information. And those things are critical to what we're trying to do here. We're trying to protect the legitimate journalist out there. And there are too many groups out there floating around that could claim that really aren't, and put perceptions out there that are incorrect. I'd really like to see some direct language in this, and am I missing it, sir?
Senator, I think on page 6 and 7
6 and
of the
7.
blue version, or are they purple versions in the Senate? Sorry. The House had that similar concern. And so we specifically listed what a definition of journalist, what a definition of news information is to try to tighten it up. And we were all aware of the similar, what's happening today in society of who is and who isn't. And that's why we added those definitions of really trying to peg down exactly who is protected and who isn't. And if they could meet that burden of, is it news? And are they a professional journalist and affiliated with a professional organization?
Okay, follow up.
Thank you, sir. Stand corrected. I don't think we ever got that far through the bill.
Okay. Any other questions from you guys? Okay, if there's anybody out in online that wants to testify, I'd like you to raise your hand now. I want you to please understand we're under a time limit, so try to be as brief as you can, and yet we want to be fair with you. So we have one coming in. Mr. Christopher, your last name's kind of cut off here. I think it's Merrill, possibly. We have two others after that it looks like are going to be wanting to come in as well. Yes, Christopher Merrill, go ahead.
Thank you, Mr. Chairman. I'm Chris Merrill, Executive Director of the Equality State Policy Center, and I'm here to speak in support of this bill. The Equality State Policy Center's mission is to ensure transparent government, fair elections, and thriving communities in Wyoming. And so a bill like this one gets at the heart of our mission. And, you know, to start, I don't want one important point to get lost in this discussion. And that's, you know, a shield law like this provides a privilege to journalists, yes, but it's really about protecting their sources. It's about protecting whistleblowers, folks who could be discouraged from speaking up and speaking out about malfeasance and corruption or what have you, if they feel like their identities can be, journalists can be forced to reveal their identities in a court. And so, you know, that's what this is about. I think the intent behind this legislation and laws like it in other states is to uphold the spirit of the United States Constitution, to help ensure that our democracy is as healthy and robust as it can be. And, you know, as you all know, the founders of this great country understood and wrote about freedom of the press. It's one of the essential ingredients of a viable democracy. You know, it's one of the necessary bulwarks against the rise of authoritarianism, the tyranny of government. And so freedom of the press helps ensure the free flow of news and information to the public. And so that, you know, that's why all these other states have some sort of shield law. You know, I think it's to uphold this spirit of the Constitution, because our democracy is best served when journalists are not inhibited from reporting the news, directly or indirectly by governmental restraint or sanction imposed by governmental process. So
we're kind of getting on a tight line, so I'd ask you to try to wrap it up, please.
I was just going to do that, Mr. Vice Chairman. So, you know, in the interest of time, I will conclude there, and I'm happy to answer any questions if there are any.
All right, thank you very much. I appreciate your having to cut it short. Is there any questions? There are none. Would we please let in Mr. Wolfson? And Mr. Wolfson, as you're coming in, I want to let you know that we're under time limit. I'm going to give you about 1.5 to 2 minutes, and I'd like to ask you to please try to hurry because we do need to get back to committee at 10. Thank you.
Sure. Mr. Vice Chairman, Senators, good morning. My name is Joshua Wolfson. I'm the editor of the Casper Star Tribune and a member of the Wyoming Press Association's Legislative Committee. I'm speaking to you today as a representative of both organizations to express support for HB 103, which of course enact a shield law in Wyoming. I've been a practicing journalist in Wyoming for the past 14 years, all with the Star Tribune. My career, I've worked both as a reporter and as an editor. During that time, we've published scores of investigative stories that required confidential sources. These sources have highlighted ongoing problems, exposed wrongdoing, or otherwise provided readers with information on their government that would have not otherwise been privy to. Shield laws are often characterized as a means to protect journalists, and that is certainly true. But what they really protect is the public's right to know. And that's why nearly every state in the union has a shield law of some sort. How do they protect the public's right to know? Please let me explain. Shield laws protect journalists from being forced by the government to turn over confidential sources. Without these protections, government entities might attempt to compel journalists through subpoenas or court orders to turn over the names of whistleblowers or other confidential sources. And if whistleblowers know that this is a possibility, that they might be outed and punished for revealing information, they are less likely to come forward. What would it mean for our understanding of Wyoming's civil life if sources refuse to come forward? I want to give you a few recent examples. Confidential whistleblowers.
About 30 seconds, please.
Confidential whistleblowers helped the Star Tribune report that our former fire chief in Casper talked to a subordinate about getting rid of unflattering video evidence after a fire escaped the city landfill and destroyed 14 homes. They also helped us to report instances of brutal bullying at a local high school and the dismissal of the University of Wyoming's former president. All are matters of considerable importance. So if I need to conclude, let me conclude a little quicker. Wyoming is a state that appreciates checks on government power. We as journalists provide one of those checks. That's why our profession is protected by the First Amendment of the Constitution. If you support government transparency, if you support holding government accountability, backing a shield law would further those aims. And I'm available for any questions. Thank you.
Thank you. I'm sorry for the shortness, but time is not on our side. Any questions? There are none. Would we please let in Mr. Martin, Brian Martin? Mr. Martin, as you come in, please try to be brief. I apologize for that, but our time's limited. Go ahead.
No problem at all. Thank you, Mr. Vice Chairman, and good morning, Senators. I am Brian Martin. I'm the managing editor of the Wyoming Tribune Eagle newspaper here in Cheyenne. I just wanted to add to what Mr. Wolfson said, since we're short on time, and let you know that through my years here as editor, I've been here 23 years, and I've encountered several situations in which sources wanted assurances that they'd remain anonymous before they would agree to talk to us. It is a very rare occurrence in Wyoming. We're not talking about a lot of situations, but the situations when this comes up, it's very, very important that journalists be allowed to talk to those sources. And just a couple of examples of where that might come into play. In this COVID-19 era, I can foresee situations where employees want to tell a reporter about their employer's comments or actions related to violations of health orders, or we have a reporter or a source within a local agency, local government agency, or state agency that wants to talk about waste of government money. And certainly the legislature is well aware and working on ways to reduce expenses. And so any way that we can root out any kind of waste or corruption, we want to talk to those sources. Our reporters are very talented, they're very skilled, and they're very professional. And several of you have mentioned that there are a variety of people claiming to be journalists these days. This shield law would go to protect the legitimate journalists, and we agreed to the provision that requires us as journalists to invoke this protection, because we don't think that it should apply to just everyone. So some larger questions about journalism are not going to be answered in this bill, but we do realize that there are a lot of issues within our profession. This is just one that we think will help protect us and our ability to do our jobs. So thank you for your consideration, and we appreciate your just time this morning. Thank you so much.
Thank you very much. Is there any questions? There are none. We appreciate you being short. Please let in Mr. Beck. And I believe that'll be the last one, I think. Okay, Mr. Jim Beck, we have about 2 minutes for you. Please be brief. I apologize for that, but our time is very, very limited.
Thank you. I appreciate the time. I'm Jim Beck. I'm a TV board member of the Wyoming Association of Broadcasters and general manager of both the TV stations owned by Gray Television in Casper and Cheyenne. I think that as other people have said, this law is really about protecting the people who talk to us. When we use a confidential source, it is our last choice and not our first choice, because on the record information is always better. So a lot of times sources start with off the record confidential sources, but then move to other things. And I think really, if you want, this law would help protect the professional journalists and really ensure that we have a free press going forward. So thank you for your time. I appreciate it.
Thank you very much for being brief. We really appreciate it, and we appreciate your comments. We actually appreciate all your comments. Are there any questions? Okay, hearing none, and there's nobody in the room. Unless some hand pops up right now, we're going to close public. Okay, we're closing public comment. What's your pleasure? Move the bill. Is there a second? I'll second it. Okay, so the bill's been moved and seconded. Sir.
Thank you, Mr. Vice Chair. I know I heard a lot about government, information and protections, but this relates to everybody, as I understand it, not just government. So let's be clear about it. It's individuals, it's other businesses, it's other things besides government. Everything's included. I'm concerned there's no penalty in here for misconduct upon using the shield law if it's used improperly. I am in favor of a shield law. I am. I don't have any issues with it. I think it serves a great purpose in trying to get data and information. But I'm concerned about the lack of consequence. And I'm sorry, maybe I'm a skeptic, but I do support the shield law, but I can't support it as written. Thank you.
Okay. there any other comments? Yes, Mr. Cooper. Senator
Thank you, Mr.
Cooper.
Chairman. My concerns kind of mirror Senator Kolb's. I got great respect for the folks that stepped up here and spoke today, but I'm more concerned about the ones that didn't. And I see a lot of potential for abuse for this, and I'd really like to have some really concrete methods of deciding who is a journalist and who isn't, because I can see a lot of opportunity for people to hide behind this law rather than for it to be used correctly. Thank you, sir.
Anybody else? No other comments? Is there any amendments? Okay, with no amendments, I guess we'll take a roll call vote.
Senator Cooper,
No.
Senator French,
No.
Senator Kolb,
No.
Senator Cost,
Aye.
and we'll leave it open for Chairman Nethercott.
Yes.
But House Bill 103 does not pass with 3 votes.
Okay, thank you. Thank you, Representative Swanisher.